Thank you all for being here again. This is an exciting panel. So the title of the panel is Heller and Protected Persons. So of course we're talking now about who is protected by the individual right to keep and bear arms from Heller and who is not. That is, who can the government exclude from the protection of the Second Amendment. Categories of people, also particular individuals. And I think as we're going to hear from the panel that there's a lot going on as the federal circuit courts in particular, but all the courts, including the state courts, have been dealing with Heller and applying it to these categories of people that can or cannot assert Second Amendment rights. And we're seeing very fractured court decisions, the sorts of things that would make absolutely devious common law exam questions, these fact patterns in these cases. But I think it's important to remember, of course, what we're looking at is a desire that's described in Heller to avoid having very dangerous people possess firearms that could harm the public. There's also, as we deal with all this uncertainty, the idea that there are people out there who want to assert a constitutional right and are concerned that if they do, they could end up in jail, right? There's very serious criminal penalties for violating a lot of these laws that deal with prohibited persons. So we're going to talk about these subjects today. We've got a great panel. We have Alan Gura, Mark Facetto, and Hannah Shear. And what we're going to do is Mark has offered to start out, and Greg has told me I'm not going to, they have amazing bios. These are three very smart people. And he has told me not to tell you about them. You can look in the program and find that out, because we need all this time to go over the discussion. So we've got remarks from each of our panelists. And I'm going to start now with Mark, and he's going to begin with our remarks. Thank you.
Great. Well, can you guys hear me? I'll talk loudly. Thank you to Campbell Law School and the Campbell Law Review for hosting this event. I'd like to also thank Professor Wallace, who took Hannah and I out shooting yesterday. I'd like to note that I've never argued in favor of gun regulation because shooting guns isn't fun. I'm going to discuss the as-applied challenges to state and federal prohibitors. I'm then going to briefly touch on the Fourth Amendment issue, which is also part of this panel. And then I'm going to take my panel prerogative and very briefly summarize the article I submitted as part of this symposium. The restrictions on firearm possessions by certain groups of people really form the heart of firearms regulation in the United States. Unlike some countries, for the most part, with some important exceptions, firearms regulation in the United States isn't really regulation of firearms directly. It's much more about who can possess and carry firearms and who can't. In fact, every Town for Gun Safety's primary legislative priority, background checks on all firearms transfers, is really just a mechanism to enforce these pre-existing prohibitors. Federal law prohibits 9 groups of people from possessing firearms, 10 if you include minors. Felons, which are defined as those who have committed crimes punishable by more than 1 year, or those who have committed crimes that were labeled misdemeanors that are punishable by more than 2 years, which will be important later. Fugitives, unlawful drug users, those who have been involuntarily committed to a mental institution, and certain other mentally ill people. Undocumented immigrants and certain non-permanent immigrants, those who have been dishonorably discharged, which I've actually recently looked into a bit, and it's really the equivalent of a felony. Most people who are kicked out of the Army aren't dishonorably discharged. They're discharged under different circumstances. Apologies. Those who have renounced their citizenship, and then those subject to domestic violence protection orders and who have committed misdemeanor crimes of domestic violence, which generally only includes relationships where there's cohabitation and excludes like girlfriend-boyfriend relationships. These prohibitors were enacted for good reason. Across most crimes, recidivism rates approach 70%. That's over the course of 3 years. And one study published by the American Journal of Public Health found that prohibiting felons from accessing firearms results in a 20 to 30% reduction in recidivism for gun crimes and violent crimes. The numbers for domestic violence are a bit lower. One study in Washington found that 25% of DV offenders reoffend within 36 months, but that almost certainly understates the problem because of the difficulties in reporting and prosecuting domestic violence. This isn't mine. To take a bit of a digression, I think the prohibitor for unlawful users of controlled substances is likely to become increasingly controversial in the next few years because of the legalization of medical marijuana and in several states recently recreational marijuana. While under federal law, marijuana is still illegal. This creates a situation where those who legally use marijuana in those states that have legalized it are still prohibited under federal law from possessing firearms. I'm only aware of one Second Amendment challenge to this, which failed in the Ninth Circuit. Alan or Hannah might be aware of more. And I really don't think there's an especially strong Second Amendment case to be made because these people continue to violate federal law. But I would expect legislative fixes to be proposed in the next few years. Returning to the issue at hand, none of the 9 federal prohibitors have been found facially invalid by a circuit court, and the vast majority of as-applied challenges have failed. As Alan mentioned yesterday, I think this is a little misleading because a lot of these challenges are occurring in the context of criminal prosecutions and sort of thrown in. They say their prosecution violates the First through 15th Amendment, and those aren't especially strong. Challenges brought by people like Alan who find sympathetic plaintiffs and are excellent lawyers are more successful. In the context of the felony prohibitor, no court has found that a prohibition based on a crime actually labeled a felony violates the Second Amendment as applied, although several have left open the possibility. It's unclear whether this openness to potential cases stems from a belief that there's a universe of currently existing prohibitors that violate the Second Amendment as applied, or whether they're just leaving open the possibility of something absurd like felony jaywalking or hyper-sympathetic plaintiffs, like the plaintiff in the Schrader case in the DC Circuit who, because of odd quirks in Maryland's law, was prohibited for a bar fight 40 years earlier that resulted in, I think, a $5 fine. The Third Circuit is the major outlier in this because of the case Binderup v. Attorney General, which Alan worked on. I'm sure we'll talk to more. Binderup involved an as-applied challenge brought by 2 plaintiffs, one who'd been convicted of corrupting a minor for a sexual relationship when he was in his 40s with a 17-year-old employee. The other involved a illegal gun carrying crime, so carrying without a license essentially, which actually occurred very close to my home in Maryland. Both crimes were misdemeanors under state law, but they were both punishable by more than 2 years. So they qualified as prohibiting under federal law. And because of quirks in state law, rights restoration wasn't available. The Third Circuit en banc found that as applied to those plaintiffs, the prohibitor was unconstitutional under the Second Amendment. And in doing so, they applied a seriousness test. If the underlying crime was serious, then it was subject to Second Amendment scrutiny, which seems like a reasonable enough test. You look at the punishment the state legislature made available for the crime. You see in this case it was 3 and 5 years respectively. Seems fairly serious. Bada bing, as applied challenge rejected. But that's not what the Third Circuit did. Rather than relying on the state legislatures to make judgments about what crimes are serious, they instead applied their own multi-factor seriousness test, beginning with the not especially reassuring note that, quote, there are no fixed criteria for determining whether crimes are serious enough to destroy Second Amendment rights, and, quote, the category of serious crimes changes over time as legislative judgments regarding virtue evolve. This second quote stems from the fact that at the time of the founding, fairly minor crimes, especially in the United Kingdom, less so in the United States, were treated as incredibly serious. This was known as the Bloody Code and punished with death sentences. Many fairly minor theft and property crimes. If you want to talk about classist law, as Glenn Reynolds did yesterday, this is the epitome of that. Factors the court did consider, although as notably not exclusive, included whether the crime was labeled a felony or misdemeanor, whether it involved the use of force, how long the sentence imposed was, and whether there's a cross-jurisdictional consensus about the seriousness of a crime. So one state can't just take this crime seriously. All the states do. Or not all the states. A majority or some large number of the states have to take the crime seriously for it to be considered serious. A factor which I think raises serious federalism concerns. Using the four-factor test, the court obviously found that these crimes were not serious. Although I think the sex crime would be interesting to be relitigated in light of the recent Me Too movement and the controversy over the Roy Moore campaign. The court then allowed the government to attempt to justify the law under intermediate scrutiny. However, they required a high degree of specificity in the intermediate scrutiny analysis. For example, the government put forward evidence that there's a fairly high rate of recidivism among sex offenders. But the court rejected that evidence because the study dealt with sex offenders who had been imprisoned, and the plaintiff in this case had not been imprisoned. Similarly, for the gun crime, they found that evidence that there's a high rate of recidivism among gun offenders couldn't be considered because that evidence cut off after 10 years, and I believe 17 years had gone by, some longer period of time. So ultimately, the court rejected the government's justifications and found that there was a constitutional violation. So this is an unworkable standard in at least two important contexts. The first is in operating state and federal background check systems. In 2016, there were 27 million background checks conducted by state and federal systems, and without clear standards, it's nearly impossible to move this many people through a system. Like all government actions, the background check system's required to comply with constitutional principles. I'm sure Alan and other people here would disagree whether it does all the time, but it's supposed to, and would presumably be required to take into consideration these as-applied cases, which it clearly isn't capable of doing. It will also make prosecuting 922G cases more difficult because instead of simply having to prove that someone is a felon, prosecutors would be required to show that the underlying felony was serious under this nebulous and confusing standard. I think the Third Circuit would have been much wiser to follow its sister circuits in applying a quasi-categorical rejection of these felony as-applied challenges, felony equivalent as-applied challenges. Moving on to the Fourth Amendment issue, I think there's likely to be a growing conflict between the continued expansion of public carry and the continued lack of accountability for police use of force. We've already started to see the tragic consequences of this disparity in cases like Tamir Rice, Philando Castile, and Daniel Shaver, who was the man killed in that horrific video that was released in December in New Mexico. The best illustration of this conflict comes from the senseless death of Andrew Scott. Mr. Scott was playing video games at home with his girlfriend at 1:30 in the morning when he heard a furious knocking at his door. It was a group of sheriff's deputies who were searching for an attempted murder suspect, but had not announced they were law enforcement. Mr. Scott, faced with this loud knocking at his door at 1:30 in the morning, picked up a handgun and held it at his side while he answered the door. When he opened the door, he took a step back from the officers and was immediately shot and killed. The officer wasn't prosecuted, and the 11th Circuit found that his estate was not entitled to any compensation because the officer's conduct was protected by qualified immunity. I'll note that the National Rifle Association was silent on all of these cases. I will also note that Alan wasn't. He's a man of principle, and he filed an amicus brief on behalf of the Second Amendment Foundation, I believe. So, commendable.
Thanks.
I don't think these are necessarily Second Amendment cases. I mean, we're discussing them in the context of the Fourth Amendment. And to the broader issue, I do think police can consider lawful possession and carrying of firearms when making stops and conducting searches. But I do think where people are exercising their rights to have firearms within their homes, or in states where firearm carriage is legal, exercising your rights or complying with state law should not make you open to summary execution. To very, very briefly mention the article that I submitted for this panel, it's on the debate surrounding the enactment of DC's public carry law in 1892, which is relevant to the next panel, potentially. So Congress passed a law requiring a showing of good cause to carry firearms in DC in 1892, with certain exceptions for open carry. To my understanding, it's the first actual debate in Congress over enacting a specific firearms regulation, and it shows the understanding of the right in the period immediately after the drafting and ratification of the 14th Amendment. Two conclusions can be drawn from this debate. The first is that there was not a clear national consensus about the meaning of the right in the period immediately after the ratification of the 14th Amendment. And the second is that to the extent there was agreement, it went along regional and political lines, with Republicans in the North and West generally supporting a more limited right to carry in public, often tied to necessity, and Democrats in the Deep South generally supporting a broader right. This didn't always hold. Republicans in Connecticut thought there was a broader right, probably because of the deep history of firearms manufacturing in Connecticut, while several Deep South states actually had fairly strong traditions of regulation, and reps from those states supported a more limited right. Personally, I think that when interpreting the Second Amendment as applied through the 14th Amendment, we should look to the views of those most responsible for the drafting and ratification. I look forward to the rest of our discussion. Thank you.
Great. Hello. Thanks so much to Judge Dietz and to my fellow panelists. So like Mark, I want to focus my remarks. Okay, I'm just going to try to speak up. I want to focus my remarks on a question that federal courts have been grappling with recently, which is how to treat as applied Second Amendment challenges to the laws that bar certain groups of people from possessing firearms. So there's been an uptick in these challenges since the Third Circuit's en banc decision in Binderup, which Mark summarized. And so this is an unsettled and I think a really important area of Second Amendment law. I'd like to kick things off by quoting a remark from a Seventh Circuit decision by Judge Easterbrook in a case called Barron. The judge was explaining why a First Amendment principle, the doctrine of prior restraint, can't be imported wholesale into the Second Amendment context. And he observed, everyone is entitled to speak and write, but not everyone is entitled to carry a concealed firearm in public. So I spoke on the last panel about how First Amendment doctrine has informed the structure of Second Amendment jurisprudence in many lower courts, specifically levels of scrutiny. But still, it's clear that the Second Amendment and First Amendment rights differ in significant ways, including because categorical limitations on who has the right to bear arms have long been accepted under the Second Amendment. So throughout Heller, the court referred to the right of law-abiding, responsible citizens to use arms in lawful self-defense, and this reflects the sensible idea that the protected right is not enjoyed by people who are not law-abiding or able to be responsible with weapons. And so what was addressed in the Binderup decision, in addition to the points that Mark went through, is that there's a body of historical evidence showing that disarming certain classes of people who have broken the law is permissible because the right to bear arms was believed to belong to virtuous citizens and be tied to one's virtue. So breaking the law would remove you from the category of virtuous citizens who fully enjoy the Second Amendment right to bear arms. Mark provided a helpful overview of the categories of people who are prohibited under federal law. There's quite a number of them. And as he mentioned, in general, courts have rejected facial challenges to those prohibitors. But the courts have had far less consensus on the availability of individualized as-applied Second Amendment challenges, and also how those challenges should be evaluated. My sense of things is that the lower courts are taking these challenges very seriously, and several as-applied challenges have been successful, and people have used that as a mechanism to regain Second Amendment rights. And I'll quickly flag that Binderup was an example of a case where the court applied intermediate scrutiny and still sided with the challengers. It wasn't like a rubber stamp that it was doing when it was applying the test of intermediate scrutiny. In Binderup, these challengers who had both committed misdemeanors that had serious enough sentences to bring them into the ambit of the federal prohibitor for felons, and some misdemeanors were nonetheless deemed to have committed crimes not sufficiently serious enough to justify continuing to prohibit them from possessing firearms. So using the felon and misdemeanor possession bans in federal law as an example, I just want to offer up a brief lay of the land of where the divisions are in the circuits and why things are so divided on this issue. So the 4th, 5th, 9th, 10th, and 11th circuits, by my count, have ruled that the federal felon possession ban is constitutional as applied to all felons. So they haven't acknowledge an ability of an individual person who has a felony conviction to claim that they shouldn't be subject to the felon possession ban based on the nature of their crime or the amount of time that's passed. Just categorically have ruled that the law is constitutional as applied to all felons. Then we have the 1st, 7th, 8th, and DC circuits that have held that this type of as-applied challenge is available to felons, although the 8th Circuit recently rejected an as-applied challenge brought by a nonviolent felon with kind of a long criminal record. That was in a case called Hewley. And a district court in DC recently also rejected an as-applied challenge brought by a nonviolent felon. So variance even there. And then finally, we have the 3rd Circuit that was addressing the same law, but people who had been convicted only of misdemeanors. And that's the case, Binderup, which sided with the challengers. I'll also flag a recent decision from the 6th Circuit on a similar law, the federal law prohibiting people convicted of misdemeanor crimes of domestic violence from possessing firearms, a case called Stimmel. The 6th Circuit rejected an as-applied challenge brought by somebody whose domestic abuse conviction was 20 years old. Their reasoning really departed from Binderup's reasoning about misdemeanor convictions. The court reasoned that some categorical restrictions on gun possession for non-law-abiding people who commit crimes are permissible under the Second Amendment, then concluded after applying intermediate scrutiny that the amendment does prohibit disarming people who have been convicted of misdemeanor domestic abuse. And then the court further concluded that the Second Amendment does not require that restrictions on the right be imposed only on an individualized case-by-case basis, nor does Heller or the Second Amendment require an individualized hearing to determine whether the government has made an improper categorization within, the set of people who have committed domestic violence misdemeanors. So I think that that's an illuminating comparison to the Binder decision, which did call for the government to provide an individualized justification for its categorization of the particular challengers as serious offenders, deserving of being subject to the felon and misdemeanor possession ban. So hopefully that will give you just some sense that the courts are a little bit all over the map on this issue. There's more prohibitors under federal law that I could talk about, but I'm trying to save you, a long discussion of all the different opinions, because there really isn't a consensus on as-applied challenges, for example, with respect to people who have been involuntarily mentally committed. There's divergence in district courts on that issue. But I wanted just to speak in broad strokes about my view of these cases. I tend to agree with a lot of what Mark has said. I think that the Second Amendment allows governments to make some categorical judgments, like that felons or domestic abuse offenders should not be permitted to possess firearms. So I agree far more with rulings like Stimmel than Binder. So I just want to highlight two points in particular that I think demonstrate the danger of rulings like Binder and why the approach taken in Stimmel fits better overall with how courts should treat as-applied constitutional challenges generally. So one is the idea that there's an appreciable risk to having courts make the determination about whether a given person who broke the law in the past should prevail on an as-applied challenge and have their gun rights restored. This isn't a determination that courts normally make or are necessarily good at making, at least not when they were not actually adjudicating a prior criminal offense or a prior mental health commitment. One cautionary statement I think is relevant comes in a U.S. Supreme Court opinion called United States versus Bean. That case involved a federal law that actually set out an administrative process for felons and misdemeanants who were barred under federal law under Section 922 G1 of the federal prohibitors, that they could apply to ATF and go through an administrative process to get their gun rights restored. But actually, Congress defunded that process, so it no longer exists. And a person who was barred under the law from possessing firearms applied to a court to try to get the same relief that ATF could have granted under the statute that is not being funded. And so the Supreme Court held that under the statute, only ATF could grant this type of relief and restore this person's gun rights. And the opinion by Justice Thomas noted that the restoration provision required applicants to demonstrate that they're not likely to act in a manner dangerous to public safety. And so Justice Thomas observed in further support of his statutory interpretation, or the court's statutory interpretation, that whether an applicant is likely to act in a manner dangerous to public safety presupposes an inquiry into that applicant's background, which is a function best performed by the executive, which, unlike courts, is institutionally equipped for conducting a neutral, wide-ranging investigation. So when courts are asked to consider an individualized as-applied challenge, by somebody who, say, has committed a crime and is asking for their gun rights to be restored under the Second Amendment, litigants are asking the court to investigate their past and make an assessment of their future dangerousness, oftentimes. That's not how all as-applied challenges have played out, but that's how some of them have gone. And so that strikes me as not the best undertaking for a court in a civil as applied constitutional challenge for the reasons that Justice Thomas cited. So the second issue I'd like to explore about this is the idea that the Binderup approach of requiring an individualized determination, an individualized justification for a possession prohibition poses extreme administrative burdens on courts. So it is extraordinarily burdensome to ask courts to relitigate someone or everyone's past felony or misdemeanor conviction, or even something like a prior involuntary commitment. And I don't think this is just a theoretical type of burden. Courts have been put in some pretty bizarre positions by the Binderup decision. So for example, a decision just came out in January from a district court, the Eastern District of Pennsylvania within the Third Circuit, in which a district court held a bench trial to adjudicate an as-applied challenge under Binderup. So the challenger had been convicted in 2005. He pled guilty to various misdemeanors, including weapons offenses and simple assault against an intimate partner. So the district court was applying Binderup to his as-applied challenge and then realized that it was necessary to hold a bench trial because there weren't any transcripts of this person's plea hearing from 2005. And so the court actually had to hear evidence for the first time of the facts underlying these criminal offenses in order to apply Binderup in this court's view. So then ultimately the court rejected the as-applied challenge after finding there was credible evidence at this hearing where the evidence was introduced for the first time that the plaintiff had violently attacked his partner while threatening to use a firearm against her. So I think obviously those were serious crimes within the meaning of Binderup, but it took this whole process to learn that. So I, just to wrap things up, I think that there's a strong argument that this type of individualized assessment isn't required by the Second Amendment, that it exceeds courts' institutional competence, and it could impose staggering burdens on the courts. So, and one observation is that when ruling on as-applied challenges involving other constitutional rights, courts have recognized that governments are permitted to impose a prophylactic rule, if the rule is generally constitutional, even if it burdens some people's constitutional rights unnecessarily or is overbroad in the way that prophylactic rules can be and sort of by nature are. So the Fifth Circuit recently cited and relied on some Supreme Court precedents taking this approach to prophylactic rules in the First Amendment context. This was the Fifth Circuit's decision in Mance, which rejected a slightly different type of as-applied Second Amendment challenge. I agree with the Mance court that those precedents about prophylactic rules, are relevant and should be considered when resolving these sorts of challenges. So with that, I'd like to turn it over to Alan.
All right, well, thank you very much. My views might be a little bit different. So if you believe, as I do, that there is a value to people having guns, that a law-abiding, responsible person who is not dangerous can not only not run the risk of committing an atrocity, but also provide some security value to society, to herself, to her family, to other people in the community, then disarming people who pose no threat to society actually carries a cost. Even the people who like to argue with John Lott and his crowd will acknowledge that there are instances of armed self-defense where the presence of a gun is socially useful. And so when we set about to disarm people, we must always keep in mind that while we need to disarm people who are dangerous, if we err and we disarm people who are not dangerous, then we endanger those people and other members of the public. Case in point, I'd like to mention an Arizona gentleman named Tom Yoxel. In 2003, he went to court and asked that a 2000 felony theft conviction that he had be reduced to a misdemeanor because he wanted to have guns. The judge agreed with that, and Mr. Yoxel, notwithstanding his what used to be a felony conviction, acquired firearms. Well, last year, about a year ago, Mr. Yoxel was driving down a lonely stretch of Arizona freeway when he came across the scene of an Arizona state trooper who had pulled over a driver. The driver had shot the trooper and started beating him to death on the ground. Mr. Yoxel was able to use his firearm that he had with him and saved the officer's life. That officer is alive today because this former felon who committed a nonviolent felony and posed no threat to society had his rights restored. And I think we're all happy about that outcome. So let's keep that in mind. Now, the idea that you can have a prophylactic rule that generally disarms categories of people who are thought to be dangerous is fine, and it's not a surprise that many of these laws are upheld. But when the law is drawn in a very broad way, as 922G1 is drawn, based not upon discrete categories of crimes, but rather the potential sentence that a legislature might prescribe for a crime, you're going to have some individual instances where people are losing their rights under circumstances that make absolutely no sense. There are many, many of these examples out there. I'll just point out a couple of them. We're all familiar with Martha Stewart, of course, a felon who told a story about her sale of the ImClone shares. And that led, of course, to a wonderful law review article by Kevin Marshall about why can't Martha Stewart have a gun, which explored some of these issues a long time ago. But I'd like to also talk about Anthony Cade Brassfield. I don't think Mr. Brassfield is here. I know he's from Florida. A number of years ago, Mr. Brassfield went to a motel in Broward County near Dana Beach, I guess it's called, with his girlfriend. And he was a very romantic fellow, and it was Valentine's Day, and he wanted to express his love for his girlfriend by doing something unfortunate. It was a little bit illegal. He brought with him these red heart-shaped helium-filled balloons that he released into the air. Officer Killjoy, that's not his name, I'm protecting the innocent here, saw this, so 5-0 came down and cited Mr. Brassfield. And you would imagine if you're a Florida lawyer, I am not, but I look things up, Mr. Brassfield could have been charged with a non-criminal infraction subject to a $250 fine, Florida Statute 379233, which prohibits the releasing of helium balloons in the vicinity of the wildlife area, which is down the road from the motel. But that's not what the officer wrote up our friend for. He actually charged him with a third-degree felony, punishable by 5 years of imprisonment for pollution. Okay, and it's interesting. I actually looked up the records in the Florida court, and it does reflect, in fact, that Mr. Brassfield was cited for the felony pollution violation, although they called it hauling waste tires without a permit, which I guess is one of the things you can do to violate the thing. And a ring like a waste tire would have been less romantic, also a felony. In any event, the charges were eventually dismissed, but it raised the question: what if he had been convicted of that? Does that warrant a permanent lifetime loss of Second Amendment rights with no possibility at all of having a federal court step in and correct that because we're too busy and it's too expensive to deal with it? A little bit troubling. And in the Binderup opinion, by the way, he pronounces it Binderup. I guess we're in the South. I've heard it called Banderup, but you guys pronounce it how you'd like. We had a couple of opinions in the Third Circuit that came up with other examples of crimes that trigger the so-called felon in possession statute at the federal level, although they're not necessarily all that serious. For example, I don't know how many folks here watch Seinfeld, right? Some people might still be my age in this room. There's an episode where Kramer and Newman have a scheme where they're going to truck bottles for recycling into Michigan to take advantage of that state's higher deposit return law. That's actually a felony in Michigan. You can't take advantage of the 10-cent deposit with a 5-cent bottle from out of state. Should Kramer and Newman have lost their Second Amendment rights? for that scheme. What about the previous 3 presidents who like to smoke marijuana? If they'd done that in Arizona, they'd be losing their Second Amendment rights forever and ever and ever. And so we can come up with all kinds of things that are felonies or misdemeanors that trigger the felon in possession prohibition. And it raises the very simple point as to why we can't avoid having, at the very least, as applied relief. The legislature can make anything a felony. The legislature can also prescribe a term of imprisonment at its discretion, okay? It doesn't matter whether anyone actually gets the sentence that the legislature has prescribed under the federal law. If it's a theoretically possible sentence, it's going to tag one as prohibited under the federal law. What about states like Massachusetts, where just about every misdemeanor is punishable by 2.5 years potential imprisonment? Selling a pig without a license in Massachusetts, second offense, no gun rights. You can look it up. I'm not sure what the connection there is, and whether or not we're prepared to deprive people of a fundamental right for such flimsy and casual reasons, and then say, oh, we're too busy, we don't want to deal with it. So there has to be some avenue for people to get relief. Now, at the state level, the states don't always follow this model that the federal government has created. There is another way to do this. Many states will itemize a list of crimes. If you've been convicted of the following 10 or 12 things, or a category of crime, drug crime, then you are prohibited. And so there's at least some thought that goes into what is it you have to do in order to trigger disarmament. And there's some relationship between what you did and why you can't have a gun. The domestic violence misdemeanor provisions is a type of law like that. And as an aside, I would mention that all the cases challenging on Second Amendment grounds domestic violence prohibition fail. It's just viewed as a different type of offense. If you're in the Navy and you beat up somebody in a bar, great, everybody wants to give you a gun. If you have a fight with a member of your family, it's like you're on a different planet and you have no gun rights. And that's just the way the courts view it. I'm not sure that that's going to change anytime in the near future. So that's a type of discrete crime that we can isolate and say, well, and there are statistics that the government will always come forward and say, well, this type of crime is special. Domestic violence misdemeanors are especially violent. They recidivate a lot with violence, and we can treat that as a discrete crime that triggers that at least facial challenge. But you need to give people some avenue of relief if you're going to draw a law as broadly as the federal government did in enacting 922G1. I think the federal government would be on much stronger grounds if it were to copy the laws of many states and simply prohibit people who have committed violent crimes or specific categories of crimes. And that would not just relieve a lot of people in the first instance of a burden that they shouldn't carry, it would also, I think, relieve the courts of any administrative burdens that they might complain about by having to adjudicate claims by people who should never have been prohibited in the first place. The other reason why courts are allowing these as-applied challenges comes from Heller itself. It's not just the logic that you can't have a fundamental right whose contours are drawn by the legislature. It's also the fact that Heller, in this magic paragraph that the Brady Center likes so much, talks about presumptively lawful restrictions. Well, judges have an understanding of what that word presumptively means. It's unconnected to the Second Amendment. It's an old doctrine. The Third Circuit and Bindrup talked about it. Presumptions can be overcome. Unless there's something written in the law that says that they can't, presumption is not conclusive. A presumption is a presumption, and it can be rebutted. So a lot of courts have said, hey, presumption, we know what to do with that. We start out with the idea that this person is prohibited, but let's hear your evidence. And let's look at the reasons. And that's from Heller. So if we're going to go down the road of applying the Heller case the way it was written by the Supreme Court, as we heard from some panelists, then that's what gets you cases like Bindrup and others like it in other circuits. Most of the case law to date in the circuits that have approved of this has been the context of a motion to dismiss or announcing the rule or rejecting it in a specific case but saying someone else could do this. Bindrup was the first decision, I believe, that we actually got to a judgment, and that's why it's significant, but it's by no means an outlier. It is a little bit strange in the sense that it broke down. The decision is a fractured opinion. I argued Bindrup and Suarez, the other case, separately to two separate panels in the Third Circuit. And before we got a decision, the court sua sponte ordered both cases reheard en banc. So then we went down to argue it en banc with 15 judges, and there was different panels of en banc because we had a senior judge who was on one panel and on the other. But in the end of the day, it was 8-7. And those 8-7 also split in different ways. There were 4 groups of judges. One group didn't write anything. You have to deduce their points of view from seeing what they joined and what they didn't join. But the main point of division was on the majority between a group of 3 judges led by Judge Ambrose and a group of 5 judges for whom Judge Hardiman wrote the opinion. Judge Ambrose wrote, I suppose, the lead opinion because he had enough judges agree with him on the preliminary aspects of it, but what he and his colleagues claimed to be the controlling opinion got 3 votes. There is a section, the last section of Judge Ambrose's opinion talks about the Marx rule and says, this is the narrowest point of decision, so my decision is the law of the circuit. That only got 3 votes too. So, your mileage may vary if you go back to the Third Circuit and draw a panel composed of one of those other 5 judges who had a very different view. So to summarize really quickly what those 2 views were, Judge Ambrose had the view that it's a 2-step analysis, and you decide whether the crime is serious or not serious, and then if you pass step 1, then the burden shifts to the government to prove that there is some reason to disarm this particular individual. All violent crimes are serious, but not all other crimes might be. And the test that he came up with was virtuousness, which was derived, as far as I can tell, from a series of law review articles. I don't think that this is a concept that was ever elucidated by anybody in the framing era in quite that term. And so then we have a test, as my colleague here pointed out, these various suggested factors as to what might make a crime virtuous or not virtuous, serious or not serious. And I do think that is somewhat tough to administer, but at least on the facts of Bindrup and Suarez, those 3 judges could say, look, this passes step 1, and there is no reason to disarm these specific individuals. The government has not come up with any evidence to do so. Judge Hardiman, writing for himself and for other judges, adopted the approach that I argued, and which is the approach that I argue all the time, which is it's not a 2-step case. It's a categorical case. You want to see if the person is entitled to Second Amendment rights. Is this a law-abiding, responsible person? That's the language from Heller. Because if somebody is a law-abiding, responsible person, the government has no interest in disarming him or her, right? And if they're not law-abiding and responsible, then they get no guns. And how do you determine whether somebody is law-abiding or responsible? It's a personal analysis of that individual. That's what as-applied claims mean. When you go into a courtroom and you're saying this is an as-applied challenge, hopefully you would frame it as applied to my personal circumstances, as applied to me, the person who's lived this life, who's done this thing, who can tell you, the reasons why I get to have guns, even if other people don't, because who knows what their story is. They're under this generally applicable prophylactic rule, which I'm not challenging. And that's how you do as applied. A lot of times we see cases that call themselves as applied, but they're as applied to the crime or as applied to nonviolent crimes, and courts get rid of those. We had a dispute in Schrader about how my complaint was written. I don't think the court gave it the correct, most generous reading of the complaint, although the government and the district judge understood what we were saying. In Schrader they said, well, sure, Mr. Schrader may personally have an issue, but we're not. We just can't read this complaint, and so we're not going to go there. So just you have to be very specific. And some of these other circuits, where like in the Ninth Circuit, there was a recent case about misprision of a felony, where they said, there's no as-applied challenge to that conviction's consequences. I read the briefs. I read that decision carefully. That was not a personal circumstances case. I would not put the Ninth Circuit in that list of circuits that are allegedly closed off to this type of argument. And in fact, I would commend to people to read the cases very carefully in the various circuits. We do have different ways of counting them up. to seeing whether or not they've truly foreclosed individualized challenges or just as applied to a category of crime or facial challenges. The SG has read some of these cases a little broader than I would read them. In any event, the issue about recidivism is also one I think that should be addressed. And this again goes to the concept of an as-applied challenge. The government always argues that anyone can recidivate from any type of crime to a more serious crime. They've argued, and they have case law that says a nonviolent property offender can recidivate with a violent crime. So if you are a shoplifter at age 17, we should take away your guns because maybe you'll murder somebody later. That is disconnected from reality. And all the recidivism statistics, I argue, are simply irrelevant to an individualized as-applied challenge. The question in Bindrup's case, in Suarez's case, in anybody's case, it's not whether other people have recidivated or might recidivate. It's what about Mr. Suarez? What about Mr. Bindrup? That's the individual who's before the court. That's the person whose rights are at stake. And a survey, we have sex offenders. We had actually a great dispute. The district judge, especially in the Bindrup case, did not appreciate and wrote a very lengthy opinion explaining why the government's arguments equating Mr. Bindrup to a sex offender were out of line. They got no traction with that, and some of that theme unfortunately found its way into the brief in the Third Circuit, and I don't think the government did itself any favors. I think they over-argued what had occurred in his circumstances. So Mr. Bindrup is not a sex offender. There's a reason why he didn't get any jail time and got a small fine and a misdemeanor conviction for which later a state judge restored his firearm rights under state law. I mean, this is not, the gymnastics doctor in Michigan, okay? A very different situation here. But in any event, recidivism is something that would support a finding that we can have a prophylactic rule about a category of crime. It's not something that comes into play when you're talking about an individual unless you show that that individual has a recent, fresh criminal history that shows that this guy just keeps violating the law and he's just going to walk out of court and commit another crime. And when you have a long rap sheet, it's easier to say that. When you have an older, nonviolent offense, a little bit harder to do so. I should mention that in the little bit of time remaining here, I guess I have like 5 minutes left, that here in the Fourth Circuit, we've seen in the context of as-applied challenges, the phenomenon that I complained about last night at the panel previously, and other people throughout this conference have noted, which is the courts, some courts, unwillingness to enforce the Second Amendment under really any circumstances. The Fourth Circuit, I think, is probably one of these courts. We came into a case called Hamilton versus Pelosi with 4 Fourth Circuit precedents that acknowledged as-applied challenges and as-applied Second Amendment relief based upon personal circumstances. These were all cases that arose in a criminal context where the person making the argument was not going to win. There was one case with an undocumented immigrant who, again, they see that as a category apart from other types of crime. And I suppose that in that situation, there's also a question about, who are the people of the United States. But putting it aside, even that case said, we are not foreclosing. We are not saying automatically anyone who commits a violation is going to lose all their rights forever. And we understand that there will be as-applied challenges. So I brought a case called Hamilton versus Pelosi, and I thought we were in pretty good shape. After all, the Fourth Circuit had a lot of law on this. What was Mr. Hamilton's situation? Well, Hamilton had been convicted of felony but nonviolent offenses in a Virginia court a number of years ago relating to a stolen credit card that he and somebody else had used to pay him back a loan, whatever. It shouldn't have been done. But it was essentially a credit card fraud situation for which he got a felony conviction. He served no jail time. He had a suspended sentence. And Mr. Hamilton subsequently got all of his rights restored under Virginia law. Both the court in Virginia and Virginia's governor restored the full panoply of rights he had lost, and that affected a federal restoration. Under the federal law, that was enough to magically restore his gun rights under 922 G1. And so Mr. Hamilton, fully enabled to possess guns in Virginia under state and federal law, became an armed guard, became a firearms instructor, and then eventually upgraded himself to become a Department of Homeland Security federal protective officer who carries a gun in Washington, D.C. to defend secure federal installations. Why did he have a lawsuit? Well, because he lives in District Heights, Maryland. And Maryland has an analog to 922G1, and they don't care about all the rights restoration that Mr. Hamilton achieved. And so we came to court and said, hey, here's a nonviolent offender whose rights have been restored by a court and by the governor. The government, the federal government entrusts him with a gun. Okay, he's essentially a law enforcement officer. And all he wants to do is have a gun at home, you know? And you've got a lot of law on this. Sounds like a strong case? Nope. Fourth Circuit said, never mind all that. We now limit our prior precedent to say that you know, if you're a felon, you're a bad person, you don't get your gun rights back. The only felons that we're going to allow to have their gun rights restored are felons who've been pardoned, okay, so who needs the restoration, or if there was a constitutional defect in their conviction, so maybe they're eligible for quorum nobis. I mean, I don't know. But the point is, it's a nonsense limitation because they're basically limiting their doctrine. In a case when they would have to actually apply it, they limited it to be essentially meaningless. The Supreme Court denied the SG's cert petition in Bindrup. It also denied my cert petition in Hamilton. So again, that reflects, I think, you know, an unwillingness, generally speaking, to address the Second Amendment at all. I think the court is conflicted internally. I don't know what's going on in there. They don't invite me to their conferences. I can't tell you. I would if I knew it. I would tell you. But those two cases are of a piece. You have the Third Circuit where judges seriously wrestled with the issue. They've fractured. Some of them have different ways of approaching it. And the Fourth Circuit, which, you know, announces an interesting limitation. One little footnote in the Hamilton case, the Fourth Circuit said, oh, misdemeanants might be different. We're not excluding misdemeanants. Wait until the next case. They'll get a misdemeanor case, and I'll put even odds that they'll find some other reason to not allow relief. But, you know, who knows? Hope springs eternal. In the meantime, there are a lot of people who are disarmed for reasons that have nothing to do with dangerousness, which is the traditional constitutionally adequate reason to disarm people. And if the courts are not too busy to convict people and send them to jail for gun crimes, then they are not too busy to actually take care that those people aren't losing their rights in ways that should not be lost. Congress can write a better law. So long as Congress does not write a better law and you have these situations, then whatever else the federal courts exist to do, I'm sorry it's expensive. I'm sorry that you know, who can be bothered to protect people's Second Amendment rights. But this is exactly the business of the federal courts, whatever it costs. If they have to do nothing else all day, this is what they should be doing, paying attention to the people's fundamental constitutional rights. Thanks.